docket. Case number 106911, State of Kansas v. Barber.
May it please the court, Mr. Barber appears through counsel Michelle Davis, and may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. This case comes before this court on petition for review, convictions for aggravated battery, intentional great bodily harm, and for child abuse. And the primary issues before this court are the district court's admission of evidence that Mr. Barber had previously shaken the baby. This was a case where Mr. Barber had called the police because the baby was having a seizure, and the child was taken to the hospital. The defense here was, I didn't do it. The child's stepmother had been with the child also before the child had the seizure. The child was in a baby swing, apparently asleep when the stepmother left. And then Mr. Barber called the police shortly thereafter. And then the child had also been with a caregiver, another caregiver, for 2 hours the night before. In fact, it's one of the witnesses who said that she had seen Mr. Barber shake the child 4 or 5 times on previous occasions. And so we challenged the district court's admission of this evidence, and then also the district court's limiting instruction to the jury as to how the jury should consider this evidence, because basically our starting point here is 6455.
What was the objection at trial, the basis for the objection at trial?
It was pursuant to the pretrial ruling that the court shouldn't be able to admit this evidence. It was the very first witness that the court, there were 2 witnesses that testified about this, and then some police officers also.
I read the objection as very vague to say, based upon our prior motions. Weren't the defense prior motions based on character evidence issues and habit, custom, the 6446 at seek statutes rather than 6455?
My understanding is that the state filed a pretrial motion for 6455 evidence, and then the court issued, and the defense filed a response opposing that, and then the court issued a ruling saying that it would allow in the prior shaking and how he responded to the child crying.
So then at instruction conference, didn't defense counsel successfully convince the court that this evidence was not a prior crime evidence?
The defense was not happy telling the jury that he may have committed prior crimes. And so the defense thought that would be prejudicial, so they asked the court to change it to prior bad acts instead of using the word crimes.
Why are we not analyzing this under 6446 at seek, those various character things, rather than 6455?
Well, because my understanding of the objection at trial was that it was a 6455 objection.
It's not that specific, but,
okay.
But let's assume that. Then how does 6455 apply? How do we have a prior crime?
Well, the prior crime would be that the evidence of the shaking. I agree that when you have evidence that he got frustrated with the child because the child was crying, that's not evidence of a prior crime.
So every shaking of a child is a crime?
Possibly, yes, because of the way the battery statute's written. I mean, all it requires is some sort of physical contact in a rude, insolent, or angry manner. And so a jury could interpret that testimony that he was frustrated, that he was telling the child to shut up, and so he rocked the child, depending on, the word rock wasn't used, but they shook the child back and forth, side to side, for 5 to 10 seconds. A jury could interpret that to be some sort of battery, some sort of physical contact in a rude, insolent, or angry manner. So that would be the prior crime. Then I can see it would be a battery.
And was that waived during the instruction conference?
I'm sorry?
Was that position waived by the defense during the instruction conference?
The defense did not object to the language that the court used in its limiting instruction.
I thought it did. I thought the defense argued there had been no evidence of a prior crime and got the court to change the language from prior crimes to bad acts.
It wasn't that they said there wasn't evidence of that. It's that they said we don't want to tell the jury, we don't want to use the word prior crimes. That could be prejudicial, to imply that our client has committed a prior crime. So we would prefer that you use the word prior bad acts, because we think that that's less prejudicial. But the defense didn't waive the whole 455 issue. I mean, the defense objected at trial. There was a pretrial objection. Then the defense objected at trial before the state started to introduce this evidence. And then the judge said, I'm going to allow this evidence in. So, and then you're getting to our second issue, but really the problem with instructing the jury that the jury's not supposed to consider this evidence for propensity. So the whole idea of the limiting instruction is to give the jury another purpose to consider the evidence, which would be such as motive, intent, opportunity, knowledge, preparation, those type of things. The problem with the instruction in this case, when it's saying course of conduct, that was basically telling the jury that's a propensity. I mean, that's saying this is the way he acts. He's acted this way before. It didn't prevent the jury from considering this evidence for propensity, which is exactly what the limiting instruction is designed to do.
We have had prior cases, though, that permitted admission of this sort of evidence for course of conduct. And so what were those cases about? What's the origin of that?
Well, I think in some cases it would be relevant, and course of conduct doesn't necessarily go to propensity. The problem in this case is it did.
I'm asking you for that case. What would be an example of the case where course of conduct is not equal to propensity evidence?
Off the top of my head, I can't give you an example of what would be. And I mean, I know I've dealt with cases that do that, where course of conduct has been okay, and it isn't a propensity type correlation, but in this case it is. But I can't give you specific facts off the top of my head of why it was okay in those other cases.
Is the more specific statute for course of conduct KSA 6449 habit and custom?
I'm sorry, can you repeat your question?
Is the more specific evidentiary statute that we should be concerned about when we're dealing with course of conduct 6449, which deals with habit and custom?
Habit and custom. Again, just off the top of my head, I really can't address that because that just hasn't been an issue in this case.
I think it was at pretrial, though. I mean, that was my earlier point. The defense motions were based upon those series of statutes, not 6455. I agree with you. The state then filed a motion under 6455, but the defense pretrial was focused on character evidence statutes and custom, habit, those types of things.
That may be, but it just never came out that way. At least in my interpretation of the record, it didn't. So,
which is part of the problem we have, I think. I think perhaps there's at least a valid argument that the wrong statute was utilized, that the trial court error was at the initial stage of deciding which statutes apply to the evidentiary questions. And admittedly, the court wasn't helped by trial counsel in that regard.
Yeah. Right, I mean, that's true. And I mean, there's a problem here where you've got the initial objection to the testimony from Jolene Brown. And then you've got other evidence that came in. For example, there's another witness that testified, and then the police officer came in, and there was no objection before the police officer testified. And again, you could say that the defense thinks just I object once and that's good enough, but...
Are you now moving into harmlessness?
In terms of the admission of the 6455?
Assuming it was aired to admit this particular evidence, wasn't there other evidence that was not objected to?
Right.
Is that where you're going in your argument?
Well, that is a problem, that there was other evidence that wasn't objected to, but I think the whole focus in this case has been, well, this is all relevant evidence. This is all relevant evidence. And it's true. I mean, it's relevant, but it's only relevant if you're looking at it for propensity. I mean, that's the problem here. So anyway, in terms of harmless, that is difficult because you're right. Some of the evidence wasn't objected to. But the strongest evidence that did come out was objected to, and that would be the testimony of Jolene Brown, and that's the testimony that I've summarized already. I think, and then the court's limiting instruction, I mean, we have a clearly erroneous standard there, but without, I think in this case it is a clearly erroneous limiting instruction because it didn't, as I've already said, it didn't limit the jury's consideration of this evidence.
What was the record on how long the stepmother had been gone when the baby started showing symptoms? Just a few minutes, or was it half an hour?
The testimony was that he came home, and shortly thereafter, maybe 10 or 15 minutes, or maybe half an hour after, the stepmother leaves and says, the child's asleep in the swing, can you watch her? And Mr. Barber reported to the police that shortly thereafter, 5 to 10 minutes maybe.
So the child was in his sole care prior to showing symptoms.
Right.
And then the medical testimony was that the symptoms would be immediately apparent after injury.
That was some of the medical testimony. There was also
there was
medical
testimony to that effect.
There was some medical testimony to that effect. There were also medical witnesses in my brief that talked about it could be a longer period of time. And so, and even the ones that said it's commonly, or in most cases, it wasn't definitive. I mean, the medical testimony wasn't. And there are doctors who said it could have been a longer period of time. So, I think I guess my best way to answer the harmless question is if you take away this evidence, and this evidence wasn't admitted, is this a reasonable doubt case? I mean, if the jury never hears that he had previously shaken the child, and it was a week prior, and I think the other key here is that that's exactly what the prosecutor argued in closing argument.
You can't
The
take all,
prosecutor-
excuse me, counsel, you can't take all of the evidence away though, because you still have the second witness. And that's it's unobjected to. You're stuck with that.
And that's-
So if you have that in combination with the two facts we just discussed.
And then I think you have to go to the limiting instruction, because I've got to say if the jury had been properly cautioned about this evidence. So it's not only the admission of the evidence, but even the evidence that wasn't objected to the jury did not get properly
Wasn't
instructed
subject
on
to a
that.
proper limiting instruction.
Right, and so the jury was told that they could consider it for course of conduct, which is, he did it before, propensity, he did it again. So if the jury had been properly cautioned in the limiting instruction, which is difficult to do, because how do you tell the jury not to consider this for propensity when it's propensity evidence? And then I think the third argument I would make, and I'm running short on time, is there's also a cumulative error sort of analysis here, because the prosecutor in closing basically called Mr. Barber's defense garbage and basically attacked him and said he thinks shaking is okay when there's no evidence of that, and basically attacked Mr. Barber, and that has to be weighed into how, and argued that the jury, that he did this because he'd done it before. And so with all of those things together.
Any further presentation, counsel?
No, thank you.
Any more questions? Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. In the brief in front of the Court of Appeals, I did argue that the objection was vague and that it wasn't even a 6455 objection, but the Court of Appeals didn't really address that argument for me. I would make that argument again today to the extent the court is willing to hear it. If it is 6455 evidence, I'm not entirely sure that it is. Generally, this would be similar to a domestic battery case since it was a child. Domestic battery requires over 18. I'm not sure there's a crime here, but if the state were to charge it with battery, I suppose that could be a crime. But the evidence here was clearly admissible. It was relevant
To course of conduct.
to course of conduct and relationship of the parties were the two reasons it was admitted.
Right. And so let's focus a little bit on your opponent's argument that here, in this case, course of conduct is equivalent or equal to propensity. Can you tell me about a case where that wouldn't be true? We've certainly had course of conduct cases in the past. Was the origin of that in a mutual, both adults and maybe a romantic relationship
Yeah.
or a marriage had gone south because of domestic abuse?
I think mostly relationship of the parties type evidence and course of conduct is indeed a domestic violence type case where there's been an ongoing escalation of violence that leads to the victim's death or
I
the
thought that
victim's
was
severe
the
harm.
origin, or the origin of that doctrine. So is it applicable when you have an adult and a child like this?
I think it's just as applicable. Here the child and the defendant is basically what the state is seeking to prove is that this child is a fussy child and the father is apparently not adept at dealing with the child when it's fussy. The child gets He gets frustrated and he shakes the child. He's done it. He did it in this case.
That's
Why is-
propensity, isn't it?
I'm sorry.
That's propensity. That's what we're struggling with, I think, or what I'm struggling with, is the difference between course of conduct and propensity. Putting aside for a moment the harmlessness question, just focusing on error.
I don't think propensity to me is more like in the drug dealing case where they had possessed drugs 10 years ago, so the drug possession here, this is a relevant case. I mean, the fact that he shook this baby when the child is upset is absolutely relevant. It's not saying that he, especially when there's, well, and this is my even...
All 6455 evidence is relevant. It's relevant that someone sold drugs 10 years ago. It's just whether it's admissible. Because it's more likely than not that a prior drug dealer would be selling drugs now than someone that's never sold drugs. So, I mean, it's all relevant. And I don't see the distinction in the domestic violence and this scenario. If you're looking at it's to show an escalation. The same thing happens with the child abuse. And in both instances, you're saying, you know, the perpetrator did it before and escalated the harm and eventually killed. So you're basing the current guilt on their past conduct, aren't you?
Not exactly. I mean, to me, 6455 in general, all the exceptions can be argued that you can turn around and say it's propensity. They did it before, they did it again. But the statute specifically says it can't be used purely for propensity. Here we're using it to show this is how he reacts when the child is upset. He does not handle the child being upset well. He was the only one alone with the child, so he was the one that did this. It's based on the totality of the facts of the case here. And I think it's the same in domestic violence cases where it's just the jury. I know it used to be res gesti, in which you guys got rid of. And that's essentially what we want because it's fair. It's the whole purpose of the 645 statute is to not bring about the wrong result.
Well, I was going to ask that question. Can you distinguish between res gesti and course of conduct? What's the distinction between those two?
Res gesti was so broad, I'm not sure that I know exactly what it was or wasn't.
Right.
to be able
I
to
think we had a
distinguish.
problem with it too.
Yeah. But course of conduct, in this case, the course of conduct was how does he react to the child when the child is upset. Res gesti I don't know what res gesti is.
Okay.
Do you have a case from another jurisdiction for us that makes the kinds of distinctions you're talking about?
No, I don't think so.
Okay.
As I remember the early cases that allowed course of conduct, McHenry and cases that followed it, the point there was to explain why a child victim had not been forthcoming to adults
It's true, they come
when he had
child abuse
when
cases, yes.
in child abuse, and so that there was a course of conduct of the manipulation of the adult, so that an intimidation of the child by the adult. In some way, we seem to have morphed far away from that to now be looking at the specific instances of conduct as proof of conduct on a later occasion, doesn't it? I mean, how is this anything but propensity evidence?
It also goes to his credibility, because the real reason this is an issue in the case is because he says he never shook the baby. If he had said, or if he had not lied to the doctors at the time when they were trying to figure out what was wrong with this child, I'm not sure this would have been as admissible. But here he said to the doctors, I never shook this child. And that's why he became the suspect, is because they went around trying to figure out who caused the injury to this child, and they learned that he had previously shaken this child.
If that's true, is the frustration basically character evidence?
I think character evidence is almost as vague as res gesti. I'm not sure what character evidence is anymore that I can, off the top of my head, answer that question. I'm sorry.
And those statutes give us some guidance, though, as to when a defendant puts his or her character into question
Right.
how we can respond.
Correct.
So is that a guide here?
Maybe. I mean, here his character is an evidence in that did he shake this child?
That's not
and
character, that's action. But
yeah.
character would be his impatience, his inability to cope, those
Yes.
sorts of things.
In that case, that's exactly what I've been arguing why it's admissible. So if that's character evidence, then yes, the character should give some guidance. I don't know. I know when I prepare for this case, it just seems like it should be admitted, and I have struggled to say why. And if I'm right, and it has been admitted, they haven't said in their limiting instruction what the jury could have been instructed on that would have been okay in this case.
But that's got it backwards.
I know.
It doesn't just
I know
come
I
in
have
'cause
to
you
prove
feel like
why it
ought
is
to.
admissible. I understand that.
Right, okay.
Until I
just
jump
so
to
you
harmless
understand
error.
that, we're good.
But here in this case, admissible or not, the error was harmless. It was admitted without objection. It was admitted, and the incident that was admitted in this case was a shaking where she later said it wasn't violent, that he was a good parent, that he was just trying to deal with it. It was a very measured admission. The other evidence in the case that he had shaken the child 5 or 6 other times. Because the evidence was already admitted and it wasn't objected to, any error in this case from the omission of the unobjected evidence was clearly harmless. Any other questions on that issue, or would you like to discuss the prosecutor misconduct?
I don't see any further questions.
All right.
Why don't you proceed as you see fit?
As to the prosecutor misconduct in this case, the prosecutor misconduct here was not gross or flagrant, and there was no ill will. I know she characterized, or defense counsel just characterized it as an attack on the defendant when she was saying garbage in, garbage out. I believe that was connected to the timeline and the fact that the defendant had multiple inconsistent statements about how long the mother had been gone. It was oratory rhetoric. The Court of Appeals, even if its analysis basically said, yeah, it was a close call one way or the other. So if it was a close call, I would argue then it couldn't be gross or flagrant. No evidence of ill will. And evidence in this case was strong. He was the only one around. The multiple medical experts said that the injuries would have immediately manifested. If there was any prosecutor misconduct in this case, there was not reversible. For those reasons, the state would ask that you affirm the convictions in this case. I'm sorry.
And it's just that last statement that threw me off.
Mm-hmm.
The Court of Appeals found misconduct, correct?
Correct.
And you didn't seek review of that finding, so we're really just down to reversibility.
Correct.
Okay.
Any further questions? Any more presentation?
No, thank you.
Thank you, counsel.
Thank you.
I think just briefly, this was not a defense at trial. When she talked about the deny the shaking, that was a doctor who testified that according to his notes, when they were at the hospital and he's asking the parents for a history, the parents said that there had not been any history of shaking or trauma to this child. So, and the doctor wasn't even sure if it was the father or the stepmother who said that. So that was one statement of a doctor. It wasn't, so for what that's worth. And then the other part is that I would just challenge the characterizing the prosecutor's comments in closing is that he gave different versions. I don't think there were that many different versions of what happened. I think he was pretty clear about he came home from work and the stepmother leaves, and then the child has seizures, and the child was in the swing, sleeping, and the child has seizures. The prosecutor in this case basically just wanted to slander Mr. Barber by saying that he thinks he's the victim here, and he's feeling sorry for himself. And even the Court of Appeals said that she was making opinion about his credibility by calling his version of events garbage, and that these were comments that were intended to inflame the jury. So I think this is clearly a case of prosecutorial misconduct. I think it's clearly intentional and had a certain purpose, and that was to get a guilty verdict.
Is it your position that getting back to the 6455 or the character evidence, however you want to characterize it, should not have come in at all, prior incidents?
The shaking is the part that's difficult here. It's one thing to say that he got frustrated with the baby's crying. He had trouble getting the baby to stop crying. It's the shaking part.
The shaking should not have come in at all.
Right.
In this case, in the prosecutor's case in chief, should not have been able to bring in any prior statements, witnesses having any kind of observations of your client shaking the baby prior to this occasion.
That is so prejudicial.
So it's your position shouldn't have come in anywhere in the trial,
Right.
at least in the case in chief.
Right, and so you've got the Jolene Brown saying that the shaking back and forth and front to back when he's frustrated, when the baby's crying, he can't get the baby to stop crying. Eventually, he puts the baby down on the bed and walks out. And then one of the police officers testified that Karen Barber said that she had seen him shaking the baby 4 to 5 times, and she had given the stepmother a pamphlet on shaken baby syndrome. That is all just so prejudicial because. It just is. I mean, I don't see how.
How do you prosecute these cases? You just prosecute them based on what the immediacy, the current act, and that's it?
I think the way the law is written and the way the statute's written, yes. I mean, you have to try them based on the events that happen and prove those events beyond a reasonable doubt.
The events contemporaneous with the injury.
Right.
So in your view, the state's evidence would primarily have been limited to establishing, as Justice Beyer was saying earlier, that the child appeared to be fine when the one adult left. It was left in the custody of the defendant. Mm-hmm. And then the child developed some symptoms. Then there was testimony saying that those symptoms are an immediate result of being shaken or some other sort of physical action. And the jury then is left with that information to say, well, it apparently happened while it was on this defendant's watch. Therefore, we conclude he's responsible. And everything else is outside the boundaries of what's admissible.
Well, in terms of the 6455 statute and the shaking the baby, yes. And I mean, I guess that's the best answer I can give you, Justice Beyer, in the course of conduct. I mean, I think even in those domestic violence cases, it shouldn't be, well, he struck her before, so he must have struck her now. It can be that maybe they have a discordant relationship. Like in this case where
in the
they're
sexual
saying,
abuse area, we've used the strikingly similar.
Mhm.
And why isn't abusing the child by shaking strikingly similar to the description of the prior abuse?
I'm not sure I understand your question. You're talking about the identity evidence?
I'm talking about the relevance of showing how this person deals with the child, how this person abuses the child. Just
Mm-hmm.
like in the sex abuse, we say if they abuse multiple children in exactly the same way, then that becomes relevant because it's a strikingly similar pattern of conduct.
Because it's relevant to show plan.
Right. And
Or method, or-
why doesn't that fit this scenario?
Because you're trying to prove plan. You're trying to prove that it's likely that they're the person because they committed a crime in a similar manner previously. So I think that the sexual abuse case I can think of is where they gave the child certain toys and they used a very specific type of toy in each case to entice children. And so the evidence is being used to show that. It's
So,
not being
in other
used
words-
for propensity. It's not being, I'm sorry.
I'm sorry to interrupt. So in other words, here, the state could have, for example, admitted this, if not to show plan, to show identity.
Well, no, because, I mean, to me, identity is you're the person behind the mask. Or there were 4 men at the scene, and you were one of those men at the scene. I mean, here, identity wasn't in question. He didn't dispute that he was the man at the scene.
But he disputed that he was the person who perpetrated the crime.
But if you read identity that broadly, then it would be relevant in every case, unless they admit that they committed the crime and it was simply by accident. I mean, if you want it, identity has to be something more narrow than that.
putting aside for the moment whether identity or plan would work for the state, and just assuming that it would, then your admission argument would go away, but you'd still have your instruction argument.
Yes.
Okay, thanks.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.